Hi, my name's Katie New, and I'm one of the attorneys at the Liker Law Firm. Today we're going to talk about discharge of debt. An individual can obtain a discharge of debt by filing for bankruptcy. A discharge of debt releases the individual's liability for many types of debts. It prevents creditors from making collection efforts upon individuals, including phone calls, letters, threats, and garnishments. Many types of unsecured debt can be discharged, including credit card debt, payday loans, and some medical bills. However, there are other types of debt that cannot be discharged through bankruptcy. Some examples of those debts are tax liabilities, student loans, and financial responsibility for any injury caused while driving while intoxicated, child support, alimony, and some types of debts to governmental agencies. Further, if there are already liens on your property, those are not discharged. The individual is still responsible for anything not discharged through bankruptcy proceedings. Discharge varies slightly between Chapter 7 and Chapter 13 filings. In a Chapter 7 bankruptcy filing, creditors are given notice of the proceedings and are given time to object. If no objections are received, the debt is generally discharged automatically. The court does have certain requirements and regulations for discharge and may not discharge if certain requirements are not met in a timely manner. Some examples of those requirements are providing tax documents and completing a course on financial management. The court may also choose not to discharge a case for any type of fraud, concealment, or failure to disclose assets. In a Chapter 13 bankruptcy, discharge of debt occurs when the reorganization plan is paid in full. In Chapter 13 filings, creditors are given the opportunity to object to the plan at a confirmation hearing, but cannot later object after completion of the payments under the plan. It's important that Chapter 7 proceedings may be revoked, the discharge, under limited circumstances. The grounds for revocation closely resemble the grounds of the court to dismiss the case without discharge, including fraud or concealment. In a Chapter 13, the court can revoke the confirmation or the discharge of the plan for fraud. After your debt is discharged, creditors are not legally allowed to attempt to collect that debt. Should a creditor attempt to collect discharged debt, a motion can be filed with the court to address the creditor. The court may punish creditors for violating a discharge order. Though a creditor cannot attempt to collect that discharged debt, you can opt to voluntarily pay the amount that was discharged. It's important to note that this can only be done after the final order has been issued and the bankruptcy is complete. This most often occurs when the relationship between the parties is of personal importance to the individual. For example, if the debts were to a family or friend of the individual that was discharged.